Let's turn our attention back to one of the most watched court cases in the country at the moment. It's the murder trial of the late Senzo Meyiwa. Let's go back to Slindelo Masikane, eNCA reporter, watching this for us. Hello to you again, Sli. And contradictions in the testimony of both the first and second witness last week. As we wrapped up last week, today we're expecting a third witness. What do we know? What are we expecting?
That's correct, Gareth. We are expecting the state's third witness to enter the witness box when we resume with court proceedings at 10 a.m. this morning. As you've stated, that we've heard testimony so far from police officers and their response in terms of what they did at the crime scene. Now, it seems as though the likelihood now is that there's going to be a focus on witness statements and witness testimony in terms of those who were present on that evening. For some legal analysis, Gareth, I am joined by legal expert, that is Mr. Marius du Toit, this morning. Thank you so much for your time. Let's just start with the fact that we're going into the third state witness, and from what we understand is that it's possibly going to be some testimony coming from a neighbor. How does the court then, Mr. du Toit, weigh up in terms of the evidence when it compares it to witness statements as opposed to the forensic evidence that we've heard so far?
So I think when the court considers a witness, Slindelo, and it's lovely to speak to you again, the court has to make a credibility finding on that witness's evidence at the end of the day. And the court has to weigh that up against circumstantial evidence, that is evidence from which you draw inferences. It has to be weighed up against the evidence of other witnesses. And then, of course, the court has to weigh it up against the written statement of the witness and to see if there's contradictions. Because if you are truthful in all material respects, it is expected of you to be consistent in what you're saying. So if you as a witness contradict your written statement, and let's say the contradiction is material, then of course it impacts on your credibility. And if the credibility is affected so adversely, then it could even result in the court rejecting your evidence outright. So the credibility of a witness is key to consider that witness's evidence. But you must always remember, the court never looks at the evidence in compartments. The court doesn't weigh up each witness on its own. The court looks at the totality of the evidence. And the court will look for that golden thread that runs through the state case that could implicate an accused, that demands an explanation from him. And if he then fails to give a proper explanation, or let's say he is very poor in the witness box, well, then the court can say, well, listen, based on the totality of the evidence, I reject your version as not being reasonably possibly true. And, you know, they always say that when it comes to a criminal case, it's always like a scale, and the scale is always in favor of the accused. And at the end of the day, the accused version only has to be reasonably possibly true, even if the court does not believe him. But the state has everything to do, because they have to prove beyond a reasonable doubt that the accused is in fact guilty. So it's going to be interesting what this neighbor brings, Slindelo. And I somehow think that he might be an eyewitness to people seeing fleeing the scene, or he might give context as to what he observed as the neighbor. So it will be really interesting to see what this evidence produces.
Now, of course, Mr. du Toit, this trial is also playing out in the court of public opinion. We know that South Africans who are interested and are watching this trial are asking themselves about those who were in the house, what they saw when they're going to be called to the stand. We know that there's a second docket at play here, where we know that those who are in the house are being accused of possibly having a case to answer to and should be in the dock. Would it be peculiar? Would it be strange if the state doesn't at any point call those who were in the house? I spoke to Katie Kumalo's lawyer this morning, Marius, and she told me that at this point the state has not said that it will be calling her client, and that at this point she's neither a suspect. So would it be strange, I think, for the state not to call those who were in the house?
So first and foremost, we have to say, Slindelo, that she is at this stage only a witness. She's not an accused. She hasn't been charged, even though many fingers are pointing in her direction. So she would be both a competent and compellable witness. So if the state wanted to call her, they could essentially subpoena her to come to court, and she would not have the right to say, I don't want to testify. The only rider or disclaimer to that is she has the right to not self-incriminate herself. So she could say, listen, I don't want to answer these questions because, I don't want to incriminate myself. And then the state would have to make a call. And you would have obviously heard that sometimes they talk of a so-called 204 witness. Now, a 204 witness is a witness that the state calls that they know that will implicate themselves, but they give this person an indemnity. If he testifies satisfactory in all material respects, the court can then indemnify this person from prosecution. The fact that Kelly Khumalo has been implicated, and there's at least rumors to that effect, the fact that we know she might be charged because we know there's a second docket, I would think it would be strange for the state to call her. The state might call other witnesses. And keeping in mind, it depends what value this witness brings. You don't just call people for the sake of calling them. You are building a case, so to speak. So the state is building this house, hoping that this house will be strong enough that at the end of the day will result in the accused being placed on his version and him coming forward to say, well, why he shouldn't be convicted at the end of the day. So this house needs to be on a firm foundation. So you just don't call people for the sake of calling them. This witness must add value to the state case. And if any of the witnesses inside the house say, we never saw anything, we only saw these suspects, can't identify them, then you have to ask yourself what value they're going to add to the trial. And if there are other witnesses in the house that have not been implicated, then you might be more inclined to call them if you just want to paint a picture for the court. So it will be interesting, but I would be really surprised, Slindelo, if they actually go so far as to call Kelly Khumalo.
Lastly, Marius, just quickly, the pace of the trial. We are sitting for the next 5 days. We're only going to resume once again in November for another 2 weeks. Just your thoughts around how this trial is moving.
Yeah, so we've had a lot of stop-starts, and I think, unfortunately, during the first part of the trial, there were sideshows going on which took away from the trial itself. And maybe that's not what a trial is about. It shouldn't be about the legal representatives. It should be ultimately about the accused's guilt. So at the end of the day, you want the trial to start, and for a speedy trial, you want it to conclude within a reasonable time. We know the judge, even if this case is postponed, will still be seized with the matter. He will finish this matter. And obviously, because the High Court has a continuous role, what that means is normally the matter is allocated for a period of time. So they would guesstimate and say, well, listen, we've got so many witnesses, so let's set it down for a month. And they would normally hope that the matter is concluded within that month or within the 2-week period. And if it isn't concluded in that period of time, then, of course, they would have to postpone to another date when the judge is available. Because remember, this judge isn't only seized with one trial. He runs many other matters. And for that reason, maybe he's not even I don't know if he's an acting judge or whether he's a judge permanently employed by the courts, by the judiciary. But, it depends on this judge's availability. Maybe he's involved in other big trials. And for that reason, it could impact on the judge's availability. It could impact on the advocate's availability. So they would try and get this matter over and done with as quickly as possible, but having regard to the fact that it's impossible to look into a crystal ball and say, this trial will only take so long, because you simply do not know. And you can't expect that, things won't jump out the woodwork during the course of the trial. So time will tell how many days we need. But I hope that by the end of this week, we'd be in a place where maybe the state could close their case, or maybe we could be in a place where the accused could start their case. Let's hope that we at least make some good headway this week.
Yeah. Thank you so much for your time this morning. That is legal expert Marius du Toit, just giving us some analysis ahead of court proceedings this morning. We'll resume at 10 a.m. It's back to you in studio.